2025 has been quite the year for immigrants, immigration lawyers, immigration law and policy. It has been crazy, and I have learned some very valuable lessons that I will be taking into 2026. So let's go over some of these things. I am U.S. immigration lawyer Lilian Chukwurah, and I have been helping my clients get green cards and citizenships for the past 10 years, and I love what I do. Now, let's get right into it. The first lesson, if you did not know this, I hope you know this by now because I have said it multiple times. Having a pending case no longer protects you from detention, from being put in removal proceedings. In previous administrations, we had a situation where if you have a pending adjustment of status application, you are not typically the target of deportation proceedings because they know you have a case pending that will lead to permanent residency. So you are typically left alone. In this administration though, having a pending case does not protect you from detention, from being put in deportation proceedings. So what does that mean for me, my clients moving forward? It means that the way that my clients and you out there navigate the world, navigate the US while your case is pending is going to be drastically different from how you were navigating the US before 2025. You do have to be more careful about traveling, even within states, between states. So if you have plans to fly from one part of the US to the other, you may want to reconsider that, especially if you are currently undocumented or in between status. Domestic flights can lead to detention. Remember, you're going through an airport, a port of entry in most situations, so you are subject to CBP search, right? So you want to make sure that you are protecting yourself and your family as much as possible. The second lesson that I want you to learn from 2025 is that you need to know your case. You need to know your case better than anyone knows your case. You need to know everything that has happened in your immigration history. If you have ever been in deportation proceedings and got out, you need to know how you got out. Okay? If you have ever filed an application before and now you don't know what happened with that application, you need to find out what happened with that application, because that can be the difference between being deported and being given a chance to file a new application. And I had this happen recently. So I am telling you, you need to know your case, or you need to have a lawyer that knows your case better than the government knows your case, okay? If you are in a position where you're not sure if an application you filed in the past can come back and hunt you, you need to get a FOIA of your records. So it's a Freedom of Information Act request through USCIS or whichever government agency that you may have filed an application with, so that you know what is on file with USCIS, what's on file with that government agency. They may not give you the full records, some things may be redacted, but it should give you a clear understanding of what you filed and what the outcome of that filing was. If you were the beneficiary of an I-130 petition, just know that you will not get that I-130 petition in your FOIA request. The petitioner needs to do a FOIA request to get the actual form I-130 and the decisions surrounding that I-130. The beneficiary is not able to get that through their FOIA request. The petitioner can get it through their FOIA request. Next lesson is that you need to prepare before you file any application. When it comes to filing petitions with USCIS, before it used to be low risk for most people to file applications with USCIS. Now, when your application is denied by USCIS, you have a higher risk of ending up in deportation proceedings. They will issue you an NTA. if your I-485 is denied, if your I-130 is denied. So it's really important that before you file that I-130, that I-485, that you make sure that you actually qualify for it, that you can stand up to the scrutiny of USCIS when it comes to your relationship. Because when you go to your interview and you mess up at the interview, there's a home visit, you mess up at the home visit, USCIS has every single right to deny your application and issue you an NTA. Again, that does not mean your marriage is not real, but that means you did not prepare for your interview. You did not prepare for the possibility of having a home visit. So preparation is such a key part of this. So you need to be prepared to make sure that you are filing the right application with the right supporting documents every single stage. Then you need to be prepared for your interview to make sure that you and your spouse, especially in a marriage-based case, you need to make sure that you and your spouse are on the same page and are able to answer questions about your relationship. And then finally, if there is an issue that happens at that interview, you need to make sure that you are prepared for a home visit, because guess what? Your file is most likely going to be referred to the fraud department. They are going to investigate, and part of that investigation can include a home visit. Do you follow me? So preparation, right? You need to prepare for every single possibility. For most of my clients, it does not go past the interview, right? We are preparing for the interview. We are doing a mock interview. We are making sure that the client has sufficient evidence to prove the relationship before we file, or at least that they will have that by the time of the interview. So you want to know that preparation is key with your immigration applications. If you're filing for naturalization, the same thing. Preparation. Have you paid off all your tax debt? Have you paid your child support or are on a payment plan for child support? Right? Have you filed your taxes every single year that you've been a permanent resident and have had a filing requirement? Those things matter. You may not think about it, but it matters. And then before you file your naturalization application, are you looking at how long you have lived in the state or in your current address? Because depending on if you just moved to a new state, a new address, and you want to file for naturalization immediately, you cannot. I have had a client where we had to delay his naturalization application for 3 months because he literally moved right before we were about to file his application. So now USCIS, where he just moved to, did not have jurisdiction for at least 3 months. So we had to show that while he was there for 3 months before we filed the naturalization application. So again, preparation, knowing what the requirements are and making sure that you are meeting those requirements at the beginning before you even file the application. Because again, the consequences, especially for adjustment of status applicants, the consequences are extreme, right? You're gonna go from having an application pending that can lead to permanent residency to potentially being given a notice to appear for immigration court. So the consequences now are intense, and you need to take it seriously and know that preparation will save you. Okay, preparation is the key. I hope you have found this video helpful. Please tell me in the comments, what are the lessons that you have learned about U.S. immigration in 2025? Let's keep this chat going, because I want to know what you have learned, because this is what I have learned as an immigration lawyer. But what have you learned as someone going through the immigration law system? So another lesson is that family preparation is so important. If you have not prepared your family for your eventual detention by ICE, please do that. Because I have had people reach out to me from my clients like, hey, we're looking for, their files that the client has, but because they're in detention, the family do not have access to it. So Why is that important? You want to make sure part of the family preparedness plan, which I talked about in a previous video, is making sure that your family is able to get access to your immigration files, your identity documents, all those things. Make sure that someone you trust has access to those documents, because if you do get detained and they need that information for your for your lawyer to present in court to try to get you out of detention, and they don't have access to it, it is going to take much longer for you to be released, okay? So it's really important that as you are going through all of these things, trying to figure out if you qualify for something and all of that, make sure you're also doing the family preparedness planning so that your family has access, or at least someone you trust has access to your immigration documents. That's why one of the first things I said is know your case. Make sure you're doing that FOIA request. Make sure that you have your documentation and that you're giving someone a copy or access to that documentation in case, right? In case the worst case scenario happens and you are detained and no longer have access to those things, now you have someone you trust that can get access to it, get that information to a lawyer, and the lawyer can now use that to actually represent you and fight for you. Okay, so take family preparedness planning very seriously. Like I said, I have a video on my channel where I talk about it in more detail. The next lesson is that cases are still being approved, right? Cases are still being approved. I don't know who needs to hear this. I don't know who needs to hear this, but cases are still being approved. Yes, it is tougher. Yes, the laws have changed. Yes, the policy has changed. However, cases are still being approved. So if you are thinking about filing but worried that things have changed so much that you're not able to file, first off, stop. Talk to an immigration lawyer first. Okay? Talk to an immigration lawyer first, because you may think that your case is not the right time to file, or many reasons. However, that's why I started with you need to know your case, you need to know your history, because depending on your background, depending on what has happened in the past, that may help determine whether this is the right time for you to file or not. I have had people come to me and there's a path for them to get a green card eventually, but that path can lead to a lot of separation that they were not ready for. But we wouldn't know that unless I knew their history, right? Unless they brought me their records and I was able to review it and be able to give them actual advice on, based on what's going on right now, this may not be the right time for you to take this step. And that's that's one thing that like a good immigration lawyer will always do. Right? They will always tell you the truth of whether this is a great time to file or whether you should hold off because of everything going on. So we're not out here just filing cases. 2025 has taught me as an immigration lawyer, and hopefully you all out there, that you do not just file a case. You need to prepare, like I said, before you file the case. Cases are still being approved. If you qualify for it, if you meet all the requirements, if you are able to document your qualifications, that you meet the requirements, your case can still be approved. Cases are still being approved. Marriage-based cases that I have filed in 2025 are all getting interviews fairly quickly. Within 6 months, they're getting interviewed, and clients are getting their green cards in a fairly short amount of time. Right? USCIS, their whole purpose for speeding up these marriage-based interviews is to see how many people they can put in deportation proceedings and deny their case and all of that. But if you know that your marriage is real, if you know that you entered with parole or with inspection, you already know you meet those basic requirements for adjustment of status in the US. So filing for adjustment of status, again, very individual specific and then risk tolerance specific as well. But when you meet the requirements and you're able to document that you meet the requirements, they will approve your case. So I'm having clients that, before it would take a year to a year and a half to get their green card based on marriage, getting their green card within 6 months because of this thing that USCIS is trying to do to see who they can catch in their net and put in deportation proceedings. It's actually benefited my clients because now they're able to get their green cards faster. Again, because their marriage is real, they had inspection, and they are able to show that they qualify for adjustment of status. Okay? So meeting the requirements is the key to getting your case approved. But just know, cases are being approved. Thank you. I say all that to say that you should not lose hope, right? You need to make sure that you qualify for the thing that you're filing for. You need to make sure that you're prepared for the thing that you're filing for, that you're ready for every single step of that process, and that you do not rush the process, right? You make sure that you are taking everything one step at a time, making sure every single requirement is met before you file, because rushing and missing requirements can lead to requests for evidence, which delays the case, and can also lead to an outright denial depending on what you're filing for. So I hope these lessons serve you well for 2026. I will be doing a future video on predictions for 2026, what I expect to happen with US immigration in 2026. If you or someone you know are going through or looking to start an immigration process and you are looking for an immigration attorney to help you with that process, please feel free to reach out to me through my website, lilylegal.com. Click on contact us and you can see the dates and times that I am available for us to chat about your case. This is a 15-minute session that is completely free, and we talk about your situation and plan out your next steps. If you would like to do this, like I said, go to my website and schedule that.